Honorable Mr. Justice Asif Saeed Khosa. I'd like to introduce him before calling him upon stage. Justice Khosa was sworn in as the 26th Chief Justice of Pakistan in January 2019. On February 18, 2010, his lordship was elevated to the position of a Supreme Court judge, and over a period of more than 19 years, he has decided about 55,000 cases, including several high-profile ones. His lordship was also part of 2 high-profile blasphemy-related cases and has tremendous contributions towards the independence of the judiciary, human rights, ethics, access to justice, judicial education, management, court administration, legal reform, consensus building, and cooperation. He has written multiple books during his career and is also a founding member of the SARC Law and was elected a member of the Board of Directors of the Commonwealth Judicial Education Institute in Halifax, Canada. His lordship secured his LLM degree from the University of Cambridge in 1978 with a specialization in public international law. He was called to the bar in July 1979 at the Honourable Society of Lincolns in London and was conferred the degree of Archer Barrister. His lordship was enrolled as an advocate of the Lahore High Court on November 1979 and later as an advocate of the Supreme Court of Pakistan in September 1985. As an advocate, he handled thousands of cases of constitutional, criminal, civil, service, revenue, and election laws in the superior courts of Pakistan. Without further ado, sir, if you could please.
Before I say anything else, I would just remind the organizers that they have to be careful. There are so many microphones on this desk that there's no place for me to put my file on. So next time, no, it's okay, but next time I think it should be taken care of. Sarah Bilal and her team, the organizers of this meeting, this event, this book launch, the Honorable former Chief Justice of Lahore High Court, Muhammad Qasim Khan Sahib, distinguished guests, ladies and gentlemen. To start with, I congratulate the Justice Project Pakistan on coming out with this wonderful book, Serving Time, Pakistan Prisons Through the Ages, written by Radha Shah. I don't identify her. If she can just raise her hand. Is she? Okay. And under the auspices of the Justice Project Pakistan. It is not a very voluminous book, so when a copy was sent to me, I hurriedly went through it because this prison system, the prisoners, and the criminal justice system as a whole is very close to my heart. So I went through the whole of it, and I found that it's a comprehensive study of laws and practices regarding prisons in this part of the world. It also encapsulates the pre- and post-independence approaches vis-a-vis prisons and prisoners. The book is full of insights and should be included in the list of compulsory reading in every law school of the country. The lawyers and judges in the country will also do well by reading this book for clarity of understanding of the relevant issues involved in our criminal justice system. So please accept my compliments on bringing out such a wonderful piece of research. I was told that I was to speak today, so I have prepared something, and the caption is Plight of Imprisoned Offenders, a Compassionate Perspective. There may be many theories as to what is to be achieved by imprisonment of an offender. Some hold that the purpose is punishment and retribution, while others maintain that it is reformation and rehabilitation which is the objective. I, however, understand that the answer lies somewhere in between. That is, to make the offender realize that he had done something wrong and that he is to improve his conduct and to conform to the norms of the society that he lives in. It is, however, of critical importance to appreciate that an imprisoned offender is also as much a citizen of the state as all of us, and above all, he is also a human being, just like us, and is thus entitled to all the constitutional, legal, and human rights applicable to him. While dealing with such an imprisoned offender, it must always be kept in view that the thick and high walls of a prison are not thick or high enough to keep the constitutional, legal, and human rights of the citizens confined therein out, and that the constitutional, legal, and human rights available to the generality of the citizenry, barring a few exceptions, do not stop being effective or operational inside the confines of a prison. I believe that denial of his rights to an imprisoned offender or treating him inhumanely dehumanizes him, which neither serves retribution nor achieves reformation. It is in this context that today I want to dilate upon some aspects which demand compassion vis-à-vis plight of the imprisoned offenders. The first point, hate crime and not the criminal. In my capacity as a judge of the Lahore High Court, I had an occasion to deal with the plight of prisoners who had served out their substantive sentences of imprisonment for the offenses committed by them, but were detained in prisons for an indefinite period merely because they had no financial capacity to pay the fines, diyat, arsh, or daman ordered to be paid by them to the state, the heirs of the victim in case of murder, or the victims themselves in cases of hurt. The case was Abid Hussain and another versus Chairman Baitul Pakistan, Baitul Mal, and others. This is PLD 2002 Lahore 482. And the opening part of my judgment handed down in that case read as follows, and I'm very proud of this passage. The court starts, and the judgment also starts with these words: putting a human being, the best of Almighty Allah's creations, in an iron cage for the rest of his life for no other reason than his abject poverty is an idea abhorrent to the dignity bestowed upon him by the Creator. And I've quoted from the Holy Quran where God Almighty says, Karramna Bani Adam, means I conferred dignity on the children of Adam. When the Holy Quran enjoins upon the believers to spend on prisoners, slaves, and those in debt, and for saving their necks and for lessening of their burdens, it sends an unmistakable message that what is to be hated is crime and not the criminal, and the unfortunate predicament of such a human being is to be visited with compassion and mercy wherever and however possible. It is manifestly in this backdrop that the Constitution of the Islamic Republic of Pakistan ensures it as a fundamental right guaranteed by Article 14 thereof, that the dignity of man is inviolable. In the case of In Re Suo Moto Constitutional Petition, which is reported as 1994 SCMR 1028, and incidentally, it was a case that somebody was to be publicly hanged. And the Amnesty International sent a telegram to the then Chief Justice of Pakistan, Justice Naseem Hasan Shah, who was my father-in-law. I was a young lawyer at that time, and my father-in-law said that here's the telegram. We were having a cup of tea at home. And he said, I've received a telegram. Can I do something? And I was young from the bar and full of ideas. And I said, yes, Article 14 of the Constitution. Dignity of man is guaranteed. So dignity of man is guaranteed, not to be classified as a man who is a criminal or not a criminal. The human being has been conferred this dignity. I said, yes, you can do a lot. And lo and behold, the Supreme Court of Pakistan held unequivocally that even the worst criminal is entitled to his dignity as a man, and the crime committed by him does not denude him of such a right, which is referable to his belonging to the human race and not to his belonging to the community of criminals. So this is what the Supreme Court held, and this is my background contribution to that. Unquote. Mind you, an imprisoned offender, though deviant in his sociological responses or interaction, is still a human being, and compassion, more than cruelty or hatred, can go a long way in curing his deviance. Point number 2, and this is interesting. The years of imprisonment are not just numbers. On a normal day, a bench of 3 judges is hearing a criminal appeal in a high court or the Supreme Court, and the case is nothing but run-of-the-mill. While deciding the question of an appropriate sentence of imprisonment for the offender, one judge, and now the Honorable former Chief Justice of Lahore High Court will appreciate it more when the judges, after hearing the case, confer with each other. One judge proposes 6 years. The second judge suggests, no, it should be 8 years. And the third judge carries the day by persuading the other 2 to settle for a middle ground, and the offender is sentenced to 7 years imprisonment. Unfortunately, all this is done quite casually and without any sensitivity to the consideration as to how long 1 year actually is, and that too in the miserable and wretched conditions of a prison. Let me give you a couple of examples to show how long 1 year away from your family, friends, and home actually is. Before his elevation as a judge of the Lahore High Court, Mr. M.R. Kiani, the legendary Justice M.R. Kiani, he was a district and sessions judge, and in one of his books, he had described his transfer to Dera Ghazi Khan, which is my hometown. He was transferred to Dera Ghazi Khan, and this is what he writes in his book, that my transfer was an exile. The word exile used by him was sufficient to convey the pain and anguish he had felt over being far away from his home and over his prolonged separation from his family and friends. The other example is that of an honorable judge of the Lahore High Court, who was my colleague and is a very dear friend. For reasons quite obvious, I shall not name him. He was sent to Bahawalpur bench of the said court for a period of 1 year. नए जजेस लगते हैं तो इधर उधर benches पे भेजते हैं कि 1 साल के लिए, and Justice Qasim Khan knows about it. I had spent 2.5 years in Multan immediately after becoming a judge. So I was wondering कि मैं फायदे में रहा हूँ, नुकसान में रहा हूँ. For reasons quite obvious, I shall not name him, and he is a very dear friend and now a very senior judge. He was sent to Bahawalpur bench of the said court for a period of 1 year. It is in my personal knowledge that within a couple of months' stay at Bahawalpur, he became so homesick and dejected that he used to literally cry out loud with a string of tears rolling down his judicial cheeks. He was so depressed that he sought refuge in poetry and in putting flowers in his books, waiting for them to dry up so as to represent his own dried up soul. Let me observe here without any fear of contradiction that although while serving in a district as a district and sessions judge and while serving at a bench of a high court, a judge of the high court spends his time of service in the lap of luxury and all possible respect and facility is extended to him by the people at large and the local administration, yet a period of 1 year away from the family, friends, and home looks like infinity to him. And I can tell you from my own experience, after a few weeks or months, every day of that year looks like a year in itself. So I can tell you from my own experience that after a few weeks or months, every day of that year looks like a year in itself. In sharp contradistinction to that 1 year of luxury turned into misery for a district and sessions judge or a judge of the High Court, kindly imagine the plight of a prisoner in jail and visualize how long a period of 1 year would be for him while living in the all too well-known, appalling, deplorable, and cruel conditions of a prison. You would be relieved to know that your task of imagining and visualizing such a plight has been made easier by Oscar Wilde in his Ballad of the Reading Gaol. Jail ko pehle English mein gaol kehte the, G-A-O-L, gaol, Old English mein. So Oscar Wilde wrote a ballad, and the title was The Ballad of Reading Gaol. And his words are beautiful. He says, I know not whether laws are right or whether the laws are wrong. All that we know who live in gaol is that the wall is strong and that each day is like a year whose days are long. Unquote. I may take this opportunity to remind the judges present and the honorable people associated with the legal profession in this room and beyond that tempering justice with mercy is not a hackneyed cliche in the legal jargon, but it is also a religious command. Adl bil ihsan. It is therefore expected that the years in a sentence of imprisonment of an offender would no longer be treated casually by judges as just numbers, and the question of a term of imprisonment for an offender would henceforth receive a consideration tempered with due sensitivity and compassion. Let me propose, and I am not joking, that it may not be a bad idea if it is made obligatory for the lawyers and judges handling criminal cases to spend a few days with prisoners inside a prison after regular intervals, so that they gain first-hand knowledge of the plight of prisoners and the actual conditions inside a prison. It might be of some interest to you to know that as a student of law at the University of Cambridge, I, along with all my classmates, had been taken to the Chelmsford prison, and we had to spend 1 full day with the prisoners inside that prison, of course, not as offenders, but as observers. Point number 3. Imprisonment means separation from the community only and nothing more. A term of imprisonment awarded against an offender simply means that by way of punishment for his misdeed, the offender is to be separated from the community for a fixed period of time. Excommunication of the offender in the medieval times was meant to serve the same purpose. Even in the present times, the panchayats in some of our villages still resort to the same punishment by ordering the wrongdoer to leave the village and not to communicate with his fellow villagers for a fixed or an indefinite period. Now that we have prisons to house the offenders, the object of imprisonment remains the same, that is, to punish the offender by separating him from the community. It is of utmost importance to understand that in such a case, the punishment is his separation from the community by limiting his daily life to the confines of a prison and there is no warrant in any law to punish him further through a cruel, inhuman, or degrading treatment inside the prison merely because he is a prisoner. The point which I want to make is that once inside a prison, the prisoner cannot be punished by the prison authorities over and above the sentence passed against him by the court unless he breaks some of the laws relating to prisons for which he can be dealt with as provided by the law. Excuse me. Dishing out cruel, inhuman, or degrading treatment to a prisoner merely because he is a prisoner is not countenanced either by the Constitution or by any other law. The right to life with its normal attributes, Article 9, prohibition against slavery, Article 11, and inviolability of dignity of man, Article 14, are some of the fundamental rights guaranteed by the Constitution, and such rights are equally available to an imprisoned offender with necessary adaptations. This means that every effort is to be made by the state to provide the necessary amenities of life to the prisoners. They are not to be treated as slaves, and their dignity as human beings is not to be violated. In short, an offender is to be punished by keeping him in prison, and he is not to be punished further merely because he is a prisoner. The Supreme Court of Pakistan has already settled this issue in the above-mentioned case of In Re Suo Motu Constitutional Petition 1994. And the relevant part I've already read out. Point number 4, and this is extremely important, and nobody bothers to even think about it. The point is that wives, children, and dependents of imprisoned offenders are punished without any fault of their own. I have spent almost half a century in the field of law, and I have yet to come across any judge who, while passing or upholding a sentence of imprisonment against an offender, is sensitive to the fact that while sending an offender to prison, he is also inflicting a punishment of a different kind upon the offender's wife and children and his other dependents who have not committed any offense at all. माँ बाप बूढ़े साथ रह रहे होते हैं, बच्चे स्कूल गोइंग हैं या पढ़ रहे हैं या छोटे हैं, suckling babies हैं, wives, they have their own rights, and somebody is to provide for them. In a country like ours, it is generally the poor who end up in prisons or languish therein for long periods, and that is because they cannot afford proper legal assistance. As good and competent lawyers are, and I say so with great respect for the noble profession of law, generally becoming more and more money-minded. I can narrate to you an incident. I was a young lawyer, and somebody came, some industrialist, some big businessman who was arrested for some offense. His son came to me, and then we started knowing each other well, and I was pursuing that case for his bail very diligently and very passionately, and because he was a resourceful person, so I thought if I win this case, I'll have many more cases from his associates and others. So I was very keen in pursuing that case. And one day, he was sitting in my office and he said, "Sir, you look very anxious in getting this case fixed for hearing, his bail matter." I said, "Shouldn't I be anxious? Your father is in jail." He said, "Sir, yes, on papers he is in jail." I was shocked. And then he told me something, and even the human rights people sitting here should notice this, that he said, "Actually, our driver is in jail in the name of my father." And they had managed everything, and the poor driver was in jail by the name of that businessman. And the businessman was sleeping in the luxury of his own bedroom. The accused persons with a comfortable financial background either successfully manage to avoid going to prison or they get out of it rather early. An offender with a poor financial background is, by and large, the sole, and this is important, this is so close to my heart, an offender with a poor financial background is, by and large, the sole breadwinner for his wife and children and his other dependents. And when he is put behind the bars, his wife and children and other dependents are literally left with no source of income or sustenance at all. In such an unfortunate situation, they initially have to become dependents of some other relatives, or when that relative starts feeling the pinch, the prisoner's wife is driven to beggary or to many other social or moral vices. His children are forced to lead the lives of orphans, their education is disturbed or discontinued, and further down the lane, all such dependents become vulnerable to the lures of the world of crime. It is a food for thought that if punishing one offender with a sentence of imprisonment opens up a possibility of producing more criminals, whereas the original objective behind such an exercise was the exact opposite of it, then there has to be something seriously wrong with the system being practiced. I have personally seen people, if somebody is in jail, his wife would start coming to you or some relative would start coming to you for legal help, and then after a time they will just disappear. And we used to wonder as lawyers, where have these people gone? Are their matters settled? But then I realized through experience that no, they have run out of resources and they have left everything to God and to the court, and the court has no time for them because nobody is pushing their case. This is a very, very serious issue. I'm sorry.
That's okay.
Thank you very much. There is, however, a silver lining available. Now there's a solution available, which I'm going to suggest. There is, however, a silver lining available, and a hint of a solution to this issue is to be found in the Constitution itself. According to the provisions of Article 10(8) of the Constitution, when a person is preventively detained and the initial period of his detention is to be extended, then such extension of the period shall be decided by the appropriate review board, which, and I quote the constitutional provision, which shall determine the place of detention of the person detained and fix a reasonable subsistence allowance for his family. There is also a problem here, and that is that such fixing of subsistence allowance for the family is applicable and relevant only to cases of preventive detention. And according to the provisions of Article 10(4) of the Constitution, preventive detention may be permissible only in cases of persons acting in a manner prejudicial to the integrity, security, or defense of Pakistan, or any part thereof, or external affairs of Pakistan, or public order, or the maintenance of supplies and services. इतने बड़े जुर्म के लिए फैमिली की सब्सिस्टेंस स्टेट देगी, कोई मामूली जुर्म कर ले तो भूखा मरेगा. So now just wait for the advice that I used to give. कि अगर कुछ करना ही है तो फिर कुछ बड़ा करके जाओ, बच्चे तो भूखे ना मरे. It is nothing but ironical that if a person issues a verbal threat to another in the ordinary course of his private dealings, or if he commits a petty trespass or theft and is imprisoned for such a crime, then the state cares a fig for his family or its sustenance in his absence. But if the same person is preventively detained over an extremely serious issue of acting in a manner prejudicial to the integrity, security, or defense of Pakistan, or any part thereof, or external affairs of Pakistan, or public order, or the maintenance of supplies or services, then the state is obliged to take care of his family and to pay a subsistence allowance to it. In such a bizarre situation, a prudent advisor to a potential poor criminal would advise him that if he has to commit a crime, then he should go for a serious one, like threatening the integrity and security or defense of Pakistan, etc., as a result of which his family would be taken care of by the state, and not to go for an ordinary crime, as a consequence of which his sourceless family would starve to death. Mark my words, the day may not be far away when some minor daughter or old wife or parent of an imprisoned offender may file a constitution petition before a high court or the Supreme Court, maintaining that she has not committed any offense, but by imprisoning her sole breadwinner on account of his having committed an offense, her right to life guaranteed by Article 9 of the Constitution has either been taken away or abridged. ये आप दोनों जो बात कर रहे हैं, मुझे लग रहा है पिटिशन तैयार हो रही है. होनी चाहिए. Why not? Nobody has thought about it so far in 75 years. I hope and expect that the state would pay heed to this serious issue before it raises its head before a court, in which situation the state may find it quite difficult to contest such a petition. Point number 5. I have 6 points, so I've already reached point 5. Be patient. Sentencing guidelines diminish discrimination. A prisoner in jail undergoing a sentence of imprisonment for 3 years for possession of chars weighing 200 grams may ask another prisoner about his conviction and sentence, and may be shocked to know that the other prisoner has been sentenced to imprisonment for 2 years for possessing the same quantity of chars. He is likely to feel discriminated against and would consider it unfair. In the case of Ghulam Murtaza and another versus the state, PLD 2009, Lahore 362, a full bench of the Lahore High Court, Lahore, had addressed this issue and had issued sentencing guidelines to be generally followed in cases involving recovery of contraband narcotic substances. I had the privilege of authoring the judgment passed in that case, and in the opening part of the same, I had observed as follows, and I quote: "The quintessence of the civilization's evolution and growth in the legal field is a progression from dispensation of justice according to the principle of justice, equity, and good conscience to justice according to law. The rationale or raison d'etre for this momentum, quite easy to discern and comprehend, is that justice ought not to be administered according to the whims, caprice, or subjective standards of an individual judge, but it should be dispensed according to some codified or stipulated standards so as to render the outcome consistent and reasonably predictable. Predictability of judicial response to an action or inaction of a person is important because by and large, people living in a community adapt or mold their conduct, keeping in view the law of the land and a probable judicial reaction to their actions or inactions. The essence, therefore, is that, proverbially speaking, justice should not vary with the size of the chancellor's foot. But a person inviting a legal intervention into his conduct should be able to appreciate in advance as to how he is likely to be treated by a judge dealing with the application of the relevant law to that person's conduct. uniformity and standardization of judicial response to similar legal situations cannot thus be overemphasized. Of late, it has been noticed by this court that in the matter of passing sentences in cases of recovery of contraband narcotic substances under the Control of Narcotic Substances Act 1997, different judges, both at the trial and the appellate stages, have been passing sentences upon convicts placed in similar situations, which sentences are quite often hideously variable, and they oscillate and fluctuate between unduly lenient and grossly oppressive. Such discrepant and vacillating judicial responses to similar situations not only give rise to confusion and uncertainty, but they also encourage unscrupulous litigants and lawyers to try to shop for a suitable judge. We have carried out a survey of all the cases reported in various law reports of the country to find out the sentencing trends of different courts and judges in cases involving recovery of contraband narcotic substances. And the information gathered through the said survey shows quite strikingly that the sentencing trends in cases of recovery of contraband narcotic substances vary quite sharply, and judicial responses in that regard differ quite drastically, even in situations which may be similar, if not identical. Such variable approaches clearly underscore the importance of uniformity and standardization in matter of sentencing in this area, and thus the efficacy and necessity of adopting a sentencing policy in that regard cannot be overstated." Unquote. Issuance of sentencing guidelines by the superior judiciary or the Ministry of Law or a law commission or a similar institution is a practice which is gaining momentum in the civilized world, and the United Kingdom and Canada are stealing the march in this respect. Such guidelines make the task of a judge in the matter of sentencing an offender easier, and standardization of sentences substantially obviates the chances of discrimination amongst convicts placed similarly. I would therefore recommend that sentencing guidelines should be prepared and introduced in our country in all major areas of criminal law, as such an exercise would go a long way in protecting and enforcing the fundamental right of the prisoners enshrined in Article 25 of the Constitution. My last and sixth point. I'm sorry I'm taking a lot of time. I don't know how many minutes were allocated, but I'm almost close to the finish. Sixth point is the concept of suspended sentence and release on parole need a favorable, fresh consideration. It is only fair to understand that if the object of imprisoning of an offender is his reformation and rehabilitation, then during his imprisonment, he needs to be afforded an opportunity to demonstrate and establish that he has made a serious and sincere effort to reform himself, and that he is ready for rehabilitation in the society as its normal member. The concepts of suspended sentence and release on parole are to be found embedded in many provisions of different laws of the country relevant to criminal cases. It would be preposterous to hold that for every kind of offense, only serving out the full sentence of imprisonment may reform the offender. There may be many petty offenses wherein a real and present threat of going to prison in case of repetition of the offense or misbehavior may deter an offender appropriately and may reform him. Similarly, in cases of longer sentences for more serious offenses, the offender may be released on parole after some time of imprisonment to establish his reformation and readiness for rehabilitation. Denial of such opportunities to the offender or the prisoner may, in the words of Shakespeare, amount to insisting upon a pound of flesh, which I, for one, would not advocate. It is of fundamental importance to appreciate in this context that a judge must never allow himself to put on the mantle of a victim or his family who may have revenge or retribution as their motivation, but a judge must always act as a neutral arbiter, trying to achieve a balance between punishment and reformation, and between retribution and rehabilitation. I would end this paper by quoting Bassanio in Shakespeare's play Merchant of Venice. बड़ा इल्ज़ाम है कि मैं लिटरेचर में बड़ा चला जाता हूँ, लेकिन जो कुछ वो लिख गए हैं उनको और तरह से बयान करना पॉसिबल नहीं होता कई दफ़ा, कूजे में दरिया को बंद कर देते. I would end my paper by quoting Bassanio in Shakespeare's play Merchant of Venice, when he was beseeching in the Duke's court for release of a prisoner, as Bassanio was ready to pay off the debt of that prisoner many times over. वो किसी से किसी ने उधार लिया था या डील की थी, पैसे देने थे, वो नहीं दे सक रहा था, प्रिजन में था, तो बसानिया कोई अच्छे दिल का मालिक था, उसने कहा जी इसके पैसे मैं भर देता हूँ, छोड़ दें, बल्कि इसके कई गुना मैं देने को तैयार हूँ, इसको छोड़ दें. उसने जो ड्यूक की कोर्ट में कहा वो ये था, कोर्ट, yes, here I tender it for him in the court, yes, twice the sum. If that will not suffice, I will be bound to pay 10 times over, on forfeit of my hands, my head, my heart. मतलब जमानत में मैं अपने हाथ, अपनी गर्दन भी देने को तैयार हूँ, बस ये पैसे ले लें और छोड़ दें इसको. If this will not suffice, अगर फिर भी आप जज साहब राजी नहीं होते, ड्यूक साहब, if this will not suffice, it must appear that malice bears down truth. And I beseech you, ये जो इतनी खूबसूरत आगे दो sentences आ रहे हैं, and I beseech you, rest once the law to your authority, to do a great right, do a little wrong. So, एक आम आदमी कह सकता है, वकील तो नहीं कह सकता कोर्ट में, लेकिन वो चूंकि वकील या जज नहीं था, लॉमैन नहीं था, तो उसने कह दिया कोर्ट में, उसने कहा जी अगर आप ये भी मेरे ऑफर नहीं मानते तो फिर नियत में फ़र्क लगता है मुझे, और कोई बात नहीं है, कोई कानून बहुत ज़्यादा रास्ते में आ रहा है तो थोड़ा सा हट के कर दें. रेस्ट वंस द लॉ टू योर अथॉरिटी, टू गो टू डू अ ग्रेट राइट, डू अ लिटिल रॉन्ग, एंड कर्ब दिस क्रूअल डेवल ऑफ हिज विल. अनकोट. I would not ask you to do a little wrong, to do a great right, but I would certainly request you to show compassion, mercy, and empathy when it comes to attending to the plight of a helpless human being rotting like a vegetable inside the strong and high walls of a prison. Now, my paper ends here, but when I was coming to this hall, something occurred to me, and as a parting thing, I would like to say that, if you permit, that our understanding or appreciation of things is generally conditioned by our own circumstances. MashaAllah, we are comfortable in life, so the walls of a prison, all those miseries and cruelties are highlighted to us, and we think this is too much. I'll give you, every coin has another side also. So I'll give you an instance of some poor person who was imprisoned and he was sent to jail in Dera Ghazi Khan. He wrote a letter to his family from inside the jail. Now this is an eye-opener. I can't read the whole letter, but the gist was, and it was in Saraiki language, but I'll translate it in English. The gist was, the accommodation is free. The accommodation is free. The rooms are pakka and cemented. Electricity is available full time. There is no load shedding. Fans are available in every room. Mattresses are provided for beds. Food is served 3 times every day without fail. We get to eat meat on many days of the week. This is not a small thing. He says, and I remember there was a lawyer who was not very successful, and one day he just stopped his scooter when I was crossing the road to go to the court, and he started talking to me. He said that I'm doing all right. कम से कम एक दिन मैं मुर्गी जरूर खिलाता हूँ family को. So this poor prisoner writes to the family that we get to eat meat on many days of the week. Free medical help is available, and even medicines are free. Everything is free of cost, and we don't have to pay for anything. Life is good, and survival is not an issue. You also come. Saraiki usne kaha, "Tusaं bhi aa vanjo." So, ladies and gentlemen, this is food for thought. Thank you very much.
Thank you, my Lord, for those insightful remarks, peppered not only with judicial references, but also a healthy dose of literary references as well. Now, moving on to the next segment, not only does this event serve to launch the hard copy of our flagship book, Serving Time, Pakistan's Prisons Through the Ages, but we are also concurrently launching our interactive webpage, which provides an immersive and layered online experience.